A sloth, a donkey, and a curious human. Send a prompt and see what they're doing. One hits record with a question on his mind. Two brothers pick it up, see what they find. Corn takes his time, Herman's got the facts. Back and forth, they never hold back. My weird prompts, come on in, that's where we begin. My weird prompts, glad you're here.
This episode was generated using artificial intelligence. Please verify facts.
My Weird Prompts is a community-driven initiative exploring how AI can fuel curiosity and uncover the fascinating ways our world works. GPU compute for this podcast is generously provided by Modal. Learn more at modal.com.
You know, Herman, I was looking at a map the other day, and it struck me how a single line on a piece of paper can be the difference between a person being a citizen, a resident, or something else entirely. It is one of those things we take for granted until we start looking at the legal plumbing beneath the surface. We often think of borders as fixed, permanent things, but in the world of international law, they are frequently more like active legal arguments. Today's prompt from Daniel is about exactly that. He wants us to break down the legal status of Israel's presence in East Jerusalem, the West Bank, and the Golan Heights.
That is a massive undertaking, Korn, and honestly, it is one of the most intellectually stimulating puzzles in international law. You have these three distinct areas that are often lumped together in news reports, but from a legal standpoint, they are treated quite differently by both the Israeli government and the international community. I am Herman Poppleberry, by the way, for anyone who needs the full name for the record, and I have been digging into the treaty law, the various United Nations resolutions, and the specific domestic statutes on this all morning. I have about 14 tabs open on my browser, ranging from the 1907 Hague Regulations to the most recent International Criminal Court filings.
I can tell. You have that look in your eye like you have found a particularly spicy footnote in a 1949 convention. But before we get into the weeds of the specific territories, we should probably establish the broad framework everyone is arguing about. We are talking about the fundamental distinction between de facto control, which is who actually runs the place on the ground, and de jure sovereignty, which is who the law says actually owns the land. In most parts of the world, those two things align. Here, they're in a state of constant high-stakes friction.
That is the perfect starting point. The overarching framework that the international community applies here is the law of belligerent occupation. This is a specific branch of the laws of war, primarily governed by the Hague Regulations of 1907 and the Fourth Geneva Convention of 1949. The basic idea is that when a state takes control of territory during a conflict that was previously under the sovereignty of another state, they are considered an occupying power. Crucially, under this framework, they do not gain ownership of the land. They are essentially temporary administrators with a very specific set of rules they have to follow until a peace treaty is signed or a final status is negotiated.
And that is where the friction begins, because Israel's position is that this occupier label does not quite fit the unique history of these lands. They often prefer the term disputed rather than occupied. Why is that word choice so legally significant?
It comes down to the sui generis argument, which basically means of its own kind, or unique. The argument, popularized by legal scholars like Yehuda Blum, is that for the law of occupation to apply in its classic sense, there has to be a recognized sovereign predecessor that was displaced. In the case of the West Bank and East Jerusalem, Israel argues that because the Jordanian annexation between 1948 and 1967 was not broadly recognized by the world, there was no legitimate sovereign to be displaced. Therefore, they argue, the land is not occupied from a legal owner, but rather disputed territory, to which Israel has a strong historical and legal claim.
It is a clever legal distinction, but the United Nations and the International Court of Justice have not really bought into it, have they?
Not at all. Most of the world maintains that the Fourth Geneva Convention applies regardless of the status of the previous ruler. They argue that the law is meant to protect the people living there, not just the rights of the previous government. But let's look at East Jerusalem first, because that is where the legal status is perhaps the most settled in Israeli law, and yet the most contested internationally.
Right, because unlike the West Bank, Israel actually formally annexed East Jerusalem. They did not just leave it under military administration.
Following the Six-Day War in 1967, Israel initially extended its law and jurisdiction to East Jerusalem through an administrative decree. Then, in 1980, the Knesset passed the Jerusalem Law, which declared that Jerusalem, complete and united, is the capital of Israel. From a domestic Israeli perspective, East Jerusalem is part of the sovereign state of Israel. It is not considered occupied territory by the Israeli courts. It is just part of the country, no different legally than Tel Aviv or West Jerusalem.
But if you step outside of the Israeli legal bubble, the view changes instantly. The international community reacted pretty strongly to that 1980 law.
They did. The United Nations Security Council passed Resolution 478 almost immediately. They declared the law null and void and called it a violation of international law. The international consensus, which remains unchanged today in 2026, is that East Jerusalem remains occupied territory. This creates a fascinating, if difficult, reality for the people living there. We talked about the human side of this in episode 1286, The Jerusalem Paradox, where we looked at how residents have permanent residency, but not necessarily citizenship.
It creates this strange legal limbo. If you are in East Jerusalem, you pay Israeli taxes, you use Israeli healthcare, and you are subject to Israeli civil law. But if you travel 10 miles away to a United Nations office, they will tell you that you are living under a military occupation. It is a total disconnect between the ground reality and the diplomatic reality. And then you have the Jerusalem envelope, the separation barrier. How does that factor into the legal status?
The barrier is a huge part of the de facto versus de jure debate. In 2004, the International Court of Justice issued an advisory opinion stating that the construction of the wall in the occupied Palestinian territory, including in and around East Jerusalem, was contrary to international law. Israel argued it was a security necessity, but the ICJ focused on how the route of the wall effectively created a fait accompli on the ground, essentially a de facto annexation of the land between the Green Line and the wall. It highlights the tension between security needs and the prohibition against the acquisition of territory by force, a cornerstone of the UN Charter.
That acquisition of territory by force principle seems to be the main hurdle for the Golan Heights as well, though the context there is a bit different.
The Golan has a similar domestic status to East Jerusalem, but a very different international context. Israel captured the Golan from Syria in 1967. Unlike the West Bank, there was an undisputed sovereign predecessor, Syria. There is no argument about who the land belonged to before the war. In 1981, Israel passed the Golan Heights Law,
which was another extension of law, jurisdiction, and administration. Move, right?
It was. It effectively annexed the territory. And just like with Jerusalem, the UN Security Council responded with Resolution 497, calling the annexation null and void and without international legal effect. However, the Golan is unique because for decades it was seen as a relatively straightforward land for peace issue. The idea was that Israel would hold the land until a peace treaty was signed with Syria, at which point it would be returned.
But then the Syrian civil war happened, and the geopolitical math changed. That is when we saw the major shift in American policy in 2019.
Right. The Trump administration issued a proclamation recognizing Israeli sovereignty over the Golan Heights. This was a massive departure from decades of American policy and international consensus. The argument from the American side was pragmatic. Given the instability in Syria and the presence of Iranian-backed forces, Israel's security required permanent control of the plateau. But it is important to note that this did not change the broader international legal consensus. Most of the world, including the European Union and the United Nations, still views the Golan as occupied Syrian territory.
So you have this situation where the United States says it is Israel. Israel says it is Israel, but the rest of the world says it is Syria under occupation. It feels like the law here is less about a set of rules and more about a set of opinions held by powerful players.
International law often functions that way, Korn. It is a combination of treaties, customary practice, and recognition. If no one recognizes your claim, it is hard to say it is legal. In a global sense, even if your domestic courts are fully behind it. It is like trying to use a currency that only one store accepts. Inside the store, it is money. Outside, it is just paper.
Now, let's tackle the big one, the West Bank, or Judea and Samaria, as it is referred to in Israeli administrative parlance. This is where the legal framework gets incredibly dense because of the Oslo Accords. It is not just a binary occupied or not situation anymore.
The West Bank is the heart of the disputed territory argument. Unlike East Jerusalem and the Golan, Israel has never formally annexed the West Bank. Instead, it is governed through a military administration. But it is not a simple military rule anymore. The Oslo Accords in the 1990s carved the territory into areas A, B, and C. This was supposed to be a 5-year interim agreement, but here we are, 30 years later, and it has become the permanent legal structure of the territory.
Let's break those down, because that is where most people get lost in the terminology.
Area A makes up about 18% of the land and is under full Palestinian Authority control, both civil and security. Area B is about 22% and is under Palestinian civil control, but Israeli security control. And Area C, which makes up about 60% of the territory, is under full Israeli civil and security control. This is where all the Israeli settlements are located.
So, from a legal perspective, does the existence of the Palestinian Authority mean it is no longer an occupation in areas A and B?
That is a point of intense debate. Israel argues that by transferring powers to the Palestinian Authority through a bilateral agreement, they have moved beyond the traditional occupier role. They see it as a contractual arrangement. However, the international view, including that of the International Court of Justice in its 2004 advisory opinion, is that Israel remains the occupying power of the entire West Bank. The argument is that as long as Israel maintains ultimate effective control over the borders, the airspace, the electromagnetic spectrum, and the movement of people and goods, the legal status of occupation persists.
It is like being the landlord of a building where the tenants have a very complicated sublease agreement, but you still hold the keys to the front door and control the electricity. You might not be in the apartment, but you are still in charge of the building.
That is a great analogy. And this leads us back to that missing reversioner theory I mentioned earlier. It was popularized by legal scholars like Yehuda Blum and Stephen Schwabel, who later became the president of the International Court of Justice. The theory goes like this. If Jordan's control of the West Bank was an illegal occupation itself, then there is no legitimate sovereign for the land to revert to. Therefore, Israel has a better claim to the land than any other state, especially given the historical and mandatory ties through the League of Nations mandate for Palestine.
You are talking about the San Remo Resolution of 1920 and the mandate which specifically earmarked the area for a Jewish national home.
The argument is that those rights were never legally extinguished. When the British left in 1948, a sovereignty vacuum was created. Jordan filled it by force, which the world did not recognize. Then Israel filled it in a defensive war in 1967. From this perspective, Israel is not occupying someone else's land. They are the rightful claimant in a territory where sovereignty has been in abeyance since the fall of the Ottoman Empire.
It is a deep historical dive that challenges the 1967 is the only date that matters narrative, but it brings us to a major friction point, the settlements. If the land is occupied, the Fourth Geneva Convention says you cannot move your own population into it. If the land is disputed or your own, those rules do not apply.
Article 49 of the Fourth Geneva Convention is the specific text everyone points to. It says, "The occupying power shall not deport or transfer parts of its own civilian population into the territory it occupies." Israel's legal defense here is twofold. First, they argue the convention does not apply because the territory was not previously the sovereign land of another state party. Second, they argue that transfer implies a forced or state-organized movement of people, whereas the settlers are moving voluntarily for ideological or economic reasons.
I have always found that distinction a bit thin, honestly. Even if they are moving voluntarily, the state provides the infrastructure, the security, the tax incentives, and the legal framework to make it possible.
The international community agrees with you on that one. The prevailing legal opinion outside of Israel is that the settlements are a violation of international law. This was reinforced by UN Security Council Resolution 2334 in 2016, which stated that the settlements have no legal validity. It was a significant resolution because the United States, under the Obama administration, chose to abstain rather than use its veto, allowing the resolution to pass.
So, we have three different statuses. East Jerusalem is annexed by Israel, but seen as occupied by the world. The Golan Heights is annexed by Israel, recognized by the US, but seen as occupied by the world. And the West Bank is under military administration, governed by the Oslo Accords, but seen as a full-blown occupation by the international community. How does this affect the actual people living there? We are talking about property rights and civil litigation.
This is where it gets really messy. In East Jerusalem, property disputes are handled in Israeli civil courts. If a Jewish organization claims ownership of a building based on pre-1948 deeds, they can sue in an Israeli court. In the West Bank, property disputes are often handled by military tribunals or through the civil administration, which is a branch of the military. If you are a Palestinian in Area C trying to build a house, you are dealing with a completely different legal system and a much higher bar for permits than a Palestinian in East Jerusalem.
We touched on this in episode 1295, the statehood question. But it is worth reiterating that these legal classifications determine whether you can be deported, whether you can vote, and what court you can appeal to if the government wants to seize your land for a road or a military zone. It is not just academic.
And this is where the International Criminal Court, or the ICC, comes in. In February of 2021, the ICC's pre-trial chamber ruled that the court has jurisdiction over the state of Palestine, which they defined as including the West Bank, Gaza, and East Jerusalem. This was a massive legal development because it allowed the prosecutor to investigate things like settlement construction as potential war crimes.
But Israel is not a member of the ICC, and neither is the US. So how does that work?
Israel argues that the ICC has no jurisdiction because there is no sovereign Palestinian state that could delegate its jurisdiction to the court in the first place. It is a circular legal argument. You cannot have a crime of occupation if there is no state being occupied, and you cannot have a court case if there is no state to bring the charges. The ICC, however, ruled that for the purposes of the Rome Statute, Palestine is a state party. It is a clash of legal universes.
It feels like we're watching two different legal realities colliding. In one universe, the UN resolutions and the ICJ opinions are the ultimate authority. In the other universe, the historical claims, the security needs, and the domestic laws of a sovereign state take precedence. Is there any precedent for this elsewhere? I mean, are there other places where a country has annexed land and eventually the world just accepted it?
There are cases, but they are rare, and usually involve much less controversy. Think about the annexation of Tibet by China or the status of Western Sahara. In the case of Western Sahara, Morocco claimed sovereignty, and the US recognized that claim in 2020 in exchange for Morocco normalizing ties with Israel. But the UN still considers it a non-self-governing territory. Or look at the Kuril Islands, which Russia took from Japan at the end of World War II. Japan still claims them, and the US supports Japan's claim, but Russia has de facto control and has integrated them into its legal system.
So the non-recognition policy can last for decades. But the Israeli case seems more codified?
It is much more deeply embedded in the international legal architecture. There are more specific resolutions, more court opinions, and more active monitoring of the Israeli situation than almost any other territorial dispute in the world. And then you have the permanent residency status in Jerusalem, which is a very specific legal construct.
Right. It is a way of saying you belong to the city, but not the state. How did that come about?
It was a direct result of the 1967 legal maneuver. When Israel extended its law to East Jerusalem, they gave the residents the option to apply for citizenship. Most declined for political reasons. They did not want to recognize the annexation. So, Israel created this middle ground status. It gives them the right to live and work in Israel and receive social benefits, but they cannot vote in national elections. It is a pragmatic solution to a legal impossibility, but it leaves people in a very vulnerable position. If they leave the city for too long, say to study abroad or work in another country, they can lose their center of life and have their residency revoked.
It is a use it or lose it sovereignty. Now, what about the crime of crimes talk? We did a whole episode on this, episode 710, about the legal definition of genocide and war crimes. How does the status of the territory affect those accusations?
It is foundational. For many of the charges brought against Israel in international forums, the occupied status is the hook that allows the law to apply. If the West Bank is not occupied, then the rules about moving populations or changing the local law do not apply in the same way. This is why the legal terminology is so fiercely contested. It is not just about names, it is about which set of international laws you are allowed to be judged by. If it is a dispute, it is a matter for negotiation. If it is an occupation, it is a matter of international criminal law.
It is like a game of legal chess where both sides are playing on the same board but using different rulebooks. One side is playing by the sovereignty and historical rights rules, and the other is playing by the human rights and decolonization rules.
And the Israeli Supreme Court has actually been a very interesting player in this. Even though they are an Israeli institution, they have often applied the international laws of belligerent occupation to the West Bank in their rulings. They have ruled that the military commander in the West Bank is limited by the Hague regulations, which require him to protect the property and welfare of the local population. So, in a weird way, the Israeli judiciary has acted as a check on the government by using the very international laws that the government sometimes tries to distance itself from.
That is a nuance I think a lot of people miss. The Israeli government might say disputed in a diplomatic brief, but the Israeli Supreme Court often says, for the purposes of this case, we will treat it as an occupation, so we can apply these humanitarian protections.
It is a functional approach. It allows the court to protect property rights or prevent certain military actions without having to make a final declaration on sovereignty, which they view as a political matter for the government to decide. It is a way of maintaining a legal order in a situation that is fundamentally disordered.
So, looking at the big picture, Daniel's prompt asks us to distinguish between these territories. If we are summarizing for someone who wants the quick version, the Golan is the most stable, in terms of its domestic legal status, especially with US recognition, but it remains a state-to-state dispute with Syria in the eyes of the UN.
And East Jerusalem is the most integrated into Israel, but also the most sensitive point of friction because of the residency issues and the religious significance of the Old City. The West Bank is the most legally complex because it is a patchwork of jurisdictions. Areas A, B, and C where military law, Ottoman law, Jordanian law, and the Oslo Accords all overlap.
And in all three cases, the international community's position is essentially frozen in 1967. They are waiting for a peace treaty that seems nowhere in sight. It makes you wonder if the law needs to evolve. Can you have a permanent occupation? Or does there come a point where the de facto reality has to be recognized as the de jure law, just so people can have a stable legal existence?
That is the debate of the 21st century. Some scholars argue for a human rights approach where the focus shifts from who owns the land to how the people on the land are treated, regardless of the sovereignty. They argue that after 60 years, the temporary nature of occupation law is no longer a useful fiction. But for now, the world is stuck in this tug of war between the 1949 conventions and the 1967 realities.
It is a lot to take in. I think the practical takeaway for most of us is that when you hear these terms, occupied, annexed, disputed, they are not just synonyms. They are specific legal claims that trigger entirely different sets of rights, responsibilities, and court jurisdictions.
If you want to understand the conflict, you have to understand the vocabulary. You cannot just look at a map, you have to look at the legal footnotes. If you're interested in diving deeper into how this affects everyday life, I really recommend checking out the archive at myweirdprompts.com. We have covered the residency issues in Jerusalem and the history of the statehood question in much more detail there.
It is one of those topics where the more you learn, the less certain you feel about the simple solutions. But that is why we do this. We're trying to shine a light on the technical foundations of these global deadlocks.
It is the complexity that makes it worth exploring. The law is not just a set of rules, it is a reflection of how we try to bring order to a very chaotic world. Sometimes it works, and sometimes it just creates a more sophisticated kind of chaos.
On that note, I think we have given the legal frameworks a pretty solid workout today. It is a stalemate, but at least now we know the specific legal statutes that define the stalemate.
It is a stalemate with a lot of paperwork, corn, a lot of very expensive, very detailed paperwork. I think I need to go close some of these tabs now before my computer melts.
Well, thank you for being the one to read it all, Herman. I will stick to the maps and the big picture questions.
Someone has to do the heavy lifting.
We should probably wrap this up before you start reading me the Hague regulations in the original French.
Tempting, but I will spare you, for now. But keep in mind, the next time you see a map of the region, look for those dotted lines. They aren't just markers of where a fence is, they are markers of where two different legal systems are currently in a state of collision.
I appreciate that. This has been a fascinating look at a topic that usually gets a lot more heat than light. Thanks to Daniel for the prompt. It really pushed us to look at the foundations of the regional deadlock.
It is a great reminder that the weird prompts are often the most important ones. They force us to look at the things we think we understand and realize how much more there is to the story.
We will have to see where the legal winds blow in the next few years. With the way things are shifting globally, who knows? Maybe we will be doing an update episode in 2027 about a whole new set of recognitions or a new ruling from the ICC.
I will keep my highlighters ready.
Thanks as always to our producer Hilbert Flumingtop for keeping the show running smoothly behind the scenes.
And a big thanks to Modal for providing the GPU credits that powered this show. We literally could not do this without that infrastructure.
This has been My Weird Prompts. If you are enjoying our deep dives into the technical and legal weeds, a quick review on your podcast app really helps us reach new listeners who appreciate this kind of analysis.
You can also find us on Spotify if you want to make sure you never miss an episode.
We will be back soon with another prompt. Until then, stay curious.
Goodbye, everyone, and cleanly.
This episode was generated using Gemini Flash 3. Text-to-speech engine was Chatterbox.
Thanks for listening to our show, My Weird Prompts, where our thoughts go from slow takes to facts on cue. We change and follow through. My Weird Prompts, that's the close from sloth